Welcome, everybody. Welcome, justices, judges, and invited guests. My name is Sherry Young, and I'm the president of the New Hampshire Supreme Court Society. And the Society is a membership organization that was created in 2007 to promote an understanding and appreciation of the New Hampshire Supreme Court and an independent and effective judiciary in New Hampshire. We are the organizers of today's event, the 2017 King Lecture, which brings prominent national legal figures to New Hampshire to present on evolving legal issues of our times. We are delighted that Judge Jeffrey Sutton and Justice David Souter will present today for the 2017 King Lecture. Special thanks to Justice Jim Bassett and Mike Lewis for helping us to pull this together. A couple of housekeeping items. Today's program will end about 4:15, following which there will be a reception outside the courtroom in the foyer area on this level until about 5 o'clock. Judge Sutton will be joining us for that reception, so if you want to introduce yourself and chat with him, that would be great. Judge Sutton will be making initial remarks, followed by a conversation between Judge Sutton, Justice Souter, and possibly Justice Bassett. There will be time for a brief question and answer to follow. And it is now my pleasure to introduce Justice Bassett, who will in turn introduce our speakers. Justice Bassett, hold on one second. Don't be too anxious.
Not so fast.
Prior to becoming a justice, Justice Bassett served for 27 years as a trial and appellate lawyer in New Hampshire, working on complex commercial and civil litigation, First Amendment, and land use cases. He was nominated by Governor John Lynch and took office in July of 2012. He's a graduate of Dartmouth College and Virginia Law School. He lives with his family in Canterbury. Before joining the bench, he was active in many nonprofits, including as a volunteer for the United Way for 25 years. He was on the board of the Capitol Center for the Arts, and this one really grabbed me. He was active with the town of Canterbury, serving 15 years on its planning board and 6 years as selectman. He's currently serving by appointment of the United States Supreme Court Chief Justice John Roberts on the High Court's Judicial Conference Advisory Committee on Evidence Rules. Okay, Justice Bassett.
Thank you very much, Sherry. Good afternoon, everybody. I'm the Junior Associate Justice. Actually, no longer am I the Junior Associate Justice at the Supreme Court as of last month, when we were joined by Justice Hans Marconi. But thank you all this afternoon for being here. And thank you very much to Sherry and Mike Lewis and the New Hampshire Supreme Court Society for all the work that they put into this event. And many thanks, too, to the federal court staff, particularly Dan Lynch and Deputy Clerk Pam Phelan, who also deserve great thanks for their hard work in making this event possible. The Society and our court hoped and expected that this lecture would attract more people than our court room across the river could hold, and that has proven to be right. Once we realized this, we reached out to our colleagues at the federal court, and they agreed to help out. We're in this beautiful courtroom here at the federal court, and it's only fitting that for a lecture about the important relationship between state and federal constitutions and the role of the state judiciary and the federal judiciary, that we are able to use it today. And it reflects the fact that the state and federal judges in New Hampshire have a close professional and personal relationship, and also between our staffs, for which our court is particularly grateful. As many of you know, we celebrated Constitution Day just this past week, so the discussion today, led by our special guests, Judge Sutton and Justice Souter, is particularly well-timed. I have the privilege of introducing the 2017 King Lecture Series guest speaker, Judge Sutton of the U.S. Court of Appeals for the Sixth Circuit, and Justice David Souter. He will join Judge Sutton for a conversation after Judge Sutton's lecture. I've had the pleasure of getting to know Judge Sutton during the past several years. We first met at a seminar at a new appellate judges seminar at NYU. Judge Sutton was the speaker, and I was at the time a very junior appellate judge. The topic was then, as it is today, the importance of state constitutions and of state Supreme Courts. I was surprised to learn during Judge Sutton's speech that many state Supreme Courts don't consult their constitution, and that the practice that we have in New Hampshire is somewhat unusual of addressing the state constitution in almost all instances. I was aware of Judge Sutton's impressive background and his credentials when I was asked to do this introduction, but just to be sure that I didn't miss anything important, I thought that I would Google him. So that's what I did. Now, I confess that I've never had the nerve to Google myself, but I'm quite sure that the top hits on any search of me would not contain the terms that came up when I searched for Judge Sutton. The first one, short list, and that's because his name is always mentioned when there's a vacancy on the U.S. Supreme Court and we have a Republican president. 2, feeder judge, and that's because Judge Sutton is one of the top 2 or 3 judges that send law clerks to the Supreme Court. Obviously, the justices at the court respect his judgment and his eye for legal talent. And 3, judicial hottie. I'm not even going to guess what this one is, but I'm hoping that it's a reference to the first 2 terms that I mentioned above.
I'm already amending my remarks.
But I can tell you a few things about Judge Sutton that you won't learn through Google or abovethelaw.com or Judgepedia. First, that he's been coming to New Hampshire since he was a young child, spending many summers at Camp Belknap. Second, he has hiked 45 of the 48 4,000-footers in New Hampshire, a commendable effort, but in his family that only earns him honorable mention because his wife and his college-age daughter have already climbed all 48. And I know that he bagged a few more this past weekend. And third, joined by his clerks, he frequently rides his bike from his chambers in Columbus, Ohio, to Cincinnati, where the Sixth Circuit sits, 100 miles each way. He says that it's no big deal because it's flat, it's Ohio, but 100 miles is still 100 miles. A graduate of Williams College and Ohio State University's Moritz College of Law, he worked as a clerk for the Second Circuit, and then at the U.S. Supreme Court for both Justices Lewis Powell and Antonin Scalia. Judge Sutton has argued 12 cases before the U.S. Supreme Court, filed over 50 merits and amicus briefs at the court, and he has argued 15 cases in state Supreme Courts. Additionally, he has served as an adjunct professor of law at Vanderbilt and a visiting lecturer at Harvard Law School. Following his time in private practice at Jones Day in Columbus, he served as Ohio's Solicitor General, and then in 2003, at age 45, he joined the Sixth Circuit. In 2016, Judge Sutton completed his term as chairman of the U.S. Supreme Court Standing Committee on the Rules, appointed to this prestigious committee by Chief Justice John Roberts. Judge Sutton is also a scholar and a prolific writer. He has written dozens of law review articles, and he is also an author. He's co-authored a book on state constitutional law. He has co-authored a book, and he has just authored a new book entitled 51 Imperfect Solutions that will be published this fall. As many of you know, Judge Sutton and his colleagues on the Sixth Circuit have had their share of high-profile cases, leading the New York Times in 2014 to call him the judge on the spot. Your Honor, I want you to know that this afternoon there's no one here from the Times, and the audience would never dream of putting you on the spot, but we're looking forward to your insights and reflections. It's also my honor to introduce retired Associate Justice of the United States Supreme Court, David Souter. Justice Souter is known for being humble and understated, yet here in New Hampshire he casts a very long and impressive shadow. Justice Souter is a graduate of both Harvard and Harvard Law School. He served our state in many ways as our state's Attorney General, as a judge on the Superior Court bench for 5 years, and then as an Associate Justice on the New Hampshire Supreme Court for 7 years. Following a period on the First Circuit Court of Appeals, Justice Souter joined the United States Supreme Court in 1990, replacing Justice William Brennan. While on the Supreme Court, Justice Souter furthered his reputation for meticulous preparation prior to oral arguments, along with polite and persistent questioning during oral arguments. When he retired in 2009, Justice Souter gained a reputation, or he retired and returned to New Hampshire, where we are fortunate that he continues to sit on a panel at the First Circuit Court of Appeals. Although retired is not really a word that can or probably ever will be used in regard to Justice Souter. Importantly, Justice Souter continues to dedicate his time and energy to speaking out on the importance of the role of civics education in maintaining a strong democracy. So we're very honored to have both Justice Souter and Judge Sutton here today, and it's my pleasure to introduce a great jurist, scholar, and a great friend, Judge Sutton.
I wish you could have kept going. Thank you, Jim. It's an honor to be here 2 days after Constitution Day and 2 days, appropriately enough, after Justice Souter's birthday. Thank you to the Historical Society and Sherry Young for arranging this invitation and bringing me back to my second home. As Jim pointed out, I spent 9 summers on Camp Belknap and Lake Winnipesaukee. Been back here just about every summer since to hike, vacation. My dad used to live here near Keene. My sister Amy, I think she's out here somewhere, and Chris. Amy works at the Carsey School and lives in Durham with her wonderful 2 children. So, and I think if all goes well, my daughter's going to live here. So that's the real hope. And then I can retire here and speak again, or maybe introduce people. That seems like the more enjoyable thing to do. So, Jim, thank you for inviting me. Thank you for arranging this. Thank you for your friendship. The short way of putting it is better people make better judges, and Jim Bassett is Exhibit A on that point. He's been a wonderful friend, and I'm so grateful to get to know him. Thank you, Justice Souter, for agreeing to do this with me. You honor me. You honor the rest of us. You know, I think everybody in New Hampshire has their own Justice Souter story. Turns out some people in Ohio have Justice Souter stories, and here's mine. So I had the good fortune of clerking at the court. We were just establishing. I met him 26 years ago. No one here will be surprised to know that Justice Souter got to know every person who worked in the Supreme Court building, including the 39 law clerks that came through every year. And it wasn't just names, it was learning a little bit about them. Of course, I very much wanted to ingratiate myself to Justice Souter, and I thought I really had a good chance at doing that with the New Hampshire thing. So every time I saw him, I mentioned this, I mentioned that, and it worked. He seemed to like me, and so before the holidays that year, we were talking about what we were going to do, and I let on that I'd be coming back to Keene to see my father for the holidays, and he said, of course, he was coming back to New Hampshire. God knows he wasn't going to stay in D.C. for Christmas, and so that was that. The holidays came and went. Come back to the court. It's January, and I'm walking down the halls, and cross paths with Justice Souter, and he goes, Jeffrey, as I was driving up to New Hampshire, it occurred to me how rude it was not to offer you and your wife a ride up there. Of course, needless to say, we had not been waiting for the invitation. There were at least 2 reasons not to wait for that invitation. Number one is not very kind. He was driving a very modest car at the time. I'm not frankly sure it would have been safe. My wife was pregnant, about 7, 8 months, and I think I would have accepted the invitation. I might have had her take a bus. But the second reason I didn't wait for that invitation is I'm fairly confident in 230 years, no U.S. Supreme Court justice has ever had a thought like that. It takes David Souter to even think of someone who wasn't clerking for him to think of offering him a ride up there. So that's Justice Souter, at least for this Ohioan. So when judges are asked to give talks, they have to make a choice. Is it going to be light or heavy? This is the Supreme Court's Historical Society talk, so sadly this is going to be heavy. But let me start with one light remark, which is somewhat apropos of Jim's cruel comment. So I came across some Department of Labor regulations recently, which do something no one should be surprised about. They describe various positions in the workforce, and it turns out they have a description for judges. Again, no surprise. They decide cases, resolve motions, read briefs, and so forth. But what caught my attention was these clever folks in D.C. at the Department of Labor thought they'd come up with opposite job descriptions. So for example, if it were up to me, I might say that a concert violinist was the opposite of a player in the National Hockey League, right? Those are opposite jobs. That leads to the question, what's the opposite job of a judge? Well, just about all of the judges that are here today are going to regret that I'm going to tell the rest of you what the opposite job of a judge is. It turns out the opposite job of a judge is a model. It gets worse. The department's guidelines proceed to describe the skills that models use most and that judges apparently use least. So here are those qualifications. Quote, the ability to maintain balance. I think there's a double entendre there, not sure. Body coordination, performing general physical activities, and stamina. Mercifully, the regulations say nothing directly about physical appearance, but that's almost assuredly assumed. So to be a judge, according to the Department of Labor, one needs to lack balance, to lack physical strength and stamina, and to be unpleasant to look at. I'm not sure I have the power to declare those regulations arbitrary and capricious, but I do think I'm in a position to say they're having far too much fun at our expense. So this judicial hottie thing, Jim, I was not planning to mention this, and you should not have mentioned this. So, people love to mock judges, and this is surely what was going on. There's a blog called Above the Law, and they thought they would do this poll of judicial hotties. And of course, Judge Kaczynski from the Ninth Circuit, whom Justice Souter knows, did some ballot stuffing and won. Second place was Justice Souter, so he would have won. I came in third. At first I thought it was kind of an honor, and then I thought, this goes back to the National Hockey League. If you say to somebody, you're the third best looking judge in the country, it's a little bit like saying you're the third best violinist in the National Hockey League, to which you say, I didn't know there were any violinists in the National Hockey League. So thanks, Jim, for having more fun at our expense. The rest of my remarks are going to be a little more serious and going to be drawn from this book I'm putting out with Oxford Publishing, actually not till the spring, on state courts and state constitutions. And so one of the chapters is about a story in American history that's not a happy story and that most of you know a little bit about and maybe a lot about, the eugenics story. So I'm going to give the side of the story you may remember in full or in part and then tell you another side of it. So if you catch a conservative on a bad day, you might be asked who has done more harm in history, the out-and-out scoundrels or the well-intentioned? Anyone who thinks that is an easy debate to win never met the eugenics movement. Started in the early 1900s, the eugenics movement grew out of the best of intentions. The idea was that society could use good breeding to improve the next generation and decrease the number of people with mental and physical disabilities, to lower crime rates, and to fix all sorts of other problems in society. Many of the most up-to-date scientists and biologists very much supported the movement. To get a sense for it, listen to this eugenicist from the early 1900s. Nearly all the happiness and nearly all the misery of the world are due not to environment, but to heredity. That the difference among men are, in the main, due to differences in the germ cells from which they are born. That social classes, therefore, which you seek to abolish by law, are ordained by nature. That it is, in the large statistical run of things, not the slums which make slum people, but slum people who make the slums. That primarily it is not the church which makes people good, but good people who make the church. That godly people are largely born and not made. That if you want artists, poets, philosophers, skilled workmen, and great statesmen, You will also have to give nature a chance to breed them. Wow, pretty jarring to modern ears. Before you ask what these eugenics proponents were thinking, it's worth remembering who was doing the thinking. These were the elite of the day: Teddy Roosevelt, the Rockefellers, the Harrimans. The center of the research for the eugenics movement was largely Harvard. Due to the efforts of the eugenicists, more than a third of the states in this country enacted involuntary sterilization laws between 1907 and 1921. Those laws applied to criminals convicted of certain crimes, and they applied to people in what used to be called colonies, homes for the disabled. In 1927, here's still part of the story that you're somewhat familiar with. In Buck versus Bell, the United States Supreme Court upheld the constitutionality of these eugenics laws in an 8-1 decision written by Oliver Wendell Holmes. The court rejected due process and equal protection challenges to the laws. While Holmes was known as a believer in judicial restraint, of allowing democracy, not the courts, to resolve difficult policy issues, that is not how he wrote the opinion. The decision not only permitted the states to enact eugenic laws, but it also provided a fervent advertisement for them. That is what leads to the infamous phrase in his opinion, 3 generations of imbeciles are enough. Justice Butler dissented, but never explained his vote, his loss, and ours. Justice Brandeis and Chief Justice Taft joined the Holmes opinion without qualification. Within 2 years of Buck versus Bell, within 2 years of 1927, 12 more states enacted eugenics laws. Over 75 years in this country, 60,000 involuntary sterilizations occurred. The movement finally died out in the 1970s and 80s with state laws passed with respect to disability discrimination, obviously at the state level, and then federal laws through the ADA in 1990. So that's the part of the Buck versus Bell story you remember in full or in part. Here's the part of the story that most people do not know. Before the 1927 Buck decision, there were 8 challenges to these state laws. 2 were filed in federal court, and 6 were filed in state court. Plaintiffs won 7 of them. The only loss was the first case, which occurred in federal court in a case called Phelan, and even in that case, within 1 year of the decision, the legislature revoked the law. So in one sense, all of the pre-Buck versus Bell cases came out the right way. The plaintiffs won all 6 challenges to the laws in the state courts, some under their federal constitutions and some under the state constitutions. 2 deserve mention. Under the Equal Protection Clause, the New Jersey Supreme Court decision in a case called Smith is particularly notable. It belongs in the pantheon of great state Supreme Court decisions, and yet very few people have heard of it. Its key objection was that the law amounted to a form of class legislation, which irrationally distinguished between individuals in group homes for the disabled and individuals with disabilities who lived with their families or could take care of themselves. If the goal was to stop individuals with disabilities from breeding, the law had it exactly backwards. One could easily monitor and restrict individuals and institutions. The same was not true of people living free from any restraint in society. Justice Holmes never mentions the Smith case in his Buck versus Bell decision. The other case is a New York State Court decision under the Due Process Clause. It showed that the science behind eugenics was at best overstated and likely wrong. Even a most modest requirement of process before each proposed sterilization would have stopped most of them in their tracks. Once again, Justice Holmes does not mention the New York State Court decision. In fact, he mentions none of the 7 decisions that favor the plaintiffs in his Buck versus Bell decision. So there are 2 pieces of good news that come out of that side of the story. The first is that the story shows that sometimes state court judges can be the progressive ones and more progressive than their colleagues on the U.S. Supreme Court. It's not necessarily in one direction. The other part of the story is that it confirms a virtue of American federalism and of limiting the powers of the national government. In 1924, the eugenicists proposed a national eugenics law, which would have permitted involuntary sterilizations in every state in the country. But then and now, most people would agree that Congress's power over interstate commerce would not permit such a law. The law was not passed. Compare the fortunes of eugenics in the United States and Germany. Over 75 years in this country, there were 60,000 involuntary sterilizations in a very large country. In Nazi Germany, in just 12 years, in a much smaller country that did not limit national power, the country had 400,000 sterilizations. There is indeed a softer side to federalism. Now here's the bad news about that side of the Buck versus Bell story. 60,000 involuntary sterilizations is too many, and there was a way to have reduced that number considerably. After Buck versus Bell, sad to say, not a single state court did what the 6 state courts had done before Buck versus Bell. No one was willing to contradict the great Oliver Wendell Holmes, even when it came to construing their own state constitutions, which each state court has a final say over. The point of the book I'm working on, and the point of what I'm going to say next, is what do we do to prevent a Buck versus Bell story happening again, and how is it that we create a culture in this country where we take seriously state constitutions and the state court's independent role in construing them? After Buck versus Bell, of course, the state courts had no right to contradict the ruling if a federal case was brought to them. But the same was not true if someone brought a state constitutional claim in state court. Buck versus Bell meant nothing to them, and they would have no obligation to follow it. I've got a few basic points. The starting point is that the greatest era in constitution writing, not just in this country, but in the world, is 1776 up to 1787, the fabled summer in Philadelphia. It's during that period that the states were doing all of the innovation when it came to constitution writing, because that was when each of the colonies was writing its own constitution. In fact, here in New Hampshire, you're proud of the fact that by many measures, yours was the first state constitution, better put, the first constitution in this country. So all of the original work when it comes to constitution writing happens at the states between 1776 and 1787. All that happens by the time the federal constitution is ratified is one form of plagiarism or another. There's nothing unique in the United States. Yeah, we should call it Plagiarism Day, but that's not going to work. It certainly is a marketing tool. But there's only one unique feature that you could patent in the federal constitution. That's federalism, splitting the atom of sovereignty, in Justice Kennedy's words. Everything else is borrowed from this constitution or that constitution, and most importantly, that's true when it comes to all of the individual rights guarantees that we take so seriously and care so much about in this country. So why is it that a state court, construing its independent state constitutional guarantees, might look at those terms or that concept differently from the United States Supreme Court? One possibility is that the language of the U.S. Constitution differs from the state Constitution's counterpart. Different language can lead to different interpretations, and there's nothing wrong with that. In fact, I would say it's to be expected. A different history behind the state constitutional guarantee and perhaps a different culture in that state also can lead to different interpretations. There's nothing wrong with that either. Think of a religious liberties case in the states of Rhode Island, Utah, Maryland. Given the unique histories of those states, they were founded by religious dissenters, it would make considerable sense that they would take those religious liberties very seriously, perhaps more seriously than other state courts or even the U.S. Supreme Court. Consider a hot-button issue like gun rights. Does it not make sense that a state with a largely rural population is going to think differently about gun rights given their culture and hunting culture, whatever it might be, versus a state with a heavy urban population? American federalism honors that difference of opinion, and there's nothing wrong with having different states taking different routes, and there's nothing wrong with some of those states being more protective of the right than the U.S. Constitution. Another reason why the state courts might chart a different path is the reality that in one sense, all U.S. Supreme Court justices are conservative, at least in a Burkean sense. They've got a jurisdiction of 320 million people, 51 sovereigns, God knows how many local city governments and county governments. When they're asked to nullify a law in a case, they're being asked to take on an awesome responsibility for a lot of people in a lot of jurisdictions. A state court faces a very different situation. It's obviously just one state. It's obviously a lot fewer people. And perhaps most importantly, at the state level, mistakes can be corrected much more easily than mistakes at the U.S. Supreme Court. At the state level, a constitution in most states can be amended with roughly a 51% vote. There's variation, but that's largely true. In most states, albeit not New Hampshire, the judges are elected, so one can change the composition of the court much more quickly than at the U.S. Supreme Court, where everybody but Justice Souter serves for 30 to 50 years. So you've got a way in which you can adjust to, respond to state court decisions that really doesn't exist at the federal level, where it's virtually impossible to change the U.S. Constitution. It takes 3/4 of the states to ratify an amendment. That doesn't happen very often. It's not likely to happen very, very soon. And of course, changing the composition of the court makes a difference as well. This federalism discount, this idea that the U.S. Supreme Court might discount in close cases the meaning of a liberty guarantee, there's no reason that should apply at the state level. If anything, it's just the opposite. Analytical disagreement is another very legitimate reason why a state court could take its own path. Think Buck versus Bell. The explanations given by the Smith court about equal protection, the New York court about due process, made a lot of sense in the early 1900s. They make a lot of sense today. No state court in the country is required to follow the reasoning of Buck versus Bell in construing its own constitution. So that kind of disagreement is healthy. It shows no lack of respect for the U.S. Supreme Court. All it shows is an honest requirement and duty to independently construe that state constitution. The other reason why a state court might disagree with the U.S. Supreme Court is there might just be a different philosophy at play. You might have an originalist decision at the U.S. Supreme Court, and yet you might have a majority at a state court that's more pragmatist or living constitutionalist, or more of a mixture. Or the opposite could be true. You could have a living constitutionalist U.S. Supreme Court decision with pragmatists and originalists taking a different path under the state constitution. The last reason for disagreement is the best reason. Most of our critical, essential liberty debates in this country when it comes to judicial review are about highly general guarantees: due process, equal protection, unreasonable search and seizure, cruel and unusual punishment, free speech. Those words are not only highly generalized, they're largely indeterminate when it comes to applying them to modern problems. The reality when it comes to judges construing such terms is you're going to have imperfect answers. There's no way a judge can say there's only one way to look at due process, and that's the only way. When we have to live with imperfection, why is it not a good idea to have 51 imperfect solutions rather than imposing just one imperfect solution on the whole country? It just doesn't make any sense. Indeterminate language should lead to vigorous state constitutionalism. Think of equal protection as a good example of this. At the federal level, as most of you probably know, we have our tiers of review: strict scrutiny, rational basis, intermediate. Professor Tribe says we have now reached the level of 7 tiers of review. That's ridiculous. No state court should go down that road. A state court should live and learn, look at what's happened with that experience, and do one of two things: get rid of the tiers of review, which is just fine as far as I'm concerned, or limit them to 2 or maybe 3, 2.5, since we're always making up these new numbers. But the reality is there's no reason why a state court should march in lockstep with an experiment that has so obviously failed to lead to principled distinctions. Perhaps the hardest part of my argument when it comes to vigorous state constitutionalism in today's partisan age is that it's entirely neutral. Forgive me. The messengers of vigorous state constitutionalism are all over the map. On the one hand, I can point to things that Justice Ginsburg, Justice Thurgood Marshall, and Justice Brennan have said, all people you could generalize are more liberal judges. They've all been vigorous proponents of independent state constitutionalism. The landmark article in this area was written by Justice Brennan in 1977, and he's saying, believe it or not, many of the same things I'm saying. Justice Scalia's last majority opinion for the court in a capital case called Kansas versus Carr. Here's what he said for all 9 members of the court. The state courts may experiment all they want with their own constitutions and often do in the wake of this court's decisions. Confirming the neutrality point, you can look not just to the messengers, but to the results. If so-called conservative results, you have takings cases, free exercise cases, administrative law decisions, all that lead to what you might call conservative outcomes. On the liberal side, you have school funding decisions, death penalty cases, criminal procedure, free speech. It's not hard to prove that vigorous state constitutionalism leads to neutral outcomes. So far, everything I've said is about something I know nothing about. I, as a federal judge, never hear state constitutional law cases, so every single thing I've said to date you should take with a very, very big grain of salt. Now let me say something I do know something about, or pretend to know something about. I get a lot of federal constitutional law cases, and I think vigorous state constitutionalism would be very good for federal constitutional law. Why? Every method for interpreting the federal Constitution would benefit from state courts that have been taking seriously their independent duty to construe their own Constitution. Think of originalists. The perspective of the originalists is, what did the guarantee mean at the time it was ratified in 1789, 1791, 1868? Where does the originalist go for evidence of what those guarantees meant? Well, as I've already showed you, all of the guarantees originated in the state constitutions, and the people that have the best insight as to what those guarantees meant are the state court judges that construe them. If you doubt me, read Justice Scalia's opinion in Heller, the gun rights case, which relies heavily on late 18th century and early 19th century state court decisions. Let's shift from the originalists to the pragmatists. What's the perspective of the pragmatists? Well, the pragmatists, in trying to figure out the meaning of a general term in the Constitution, wants to know at a minimum what is likely to work. What's the best evidence for how an interpretation might work? By looking at a state court that has adopted a given interpretation, lived with it for a while, and seeing how it could be implemented. Another state court tries something different, and still a third state court tries something different from the first two. Now, the pragmatist U.S. Supreme Court justice has something to look at. Without vigorous state constitutionalism, they have nothing to look at. Now, the living constitutionalist. The living constitutionalist looks for changes in society's norms and values as things that ought to be considered, at least sometimes, in construing general guarantees in the Constitution. But the living constitutionalist can't wake up in the morning, look in the mirror, and see an image of the Constitution that reflects their worldview. That, of course, is not going to work. They're going to have to look outside themselves for evidence of these shifting American norms. Where better to look than state court decisions about shifting norms, state legislation for shifting norms. In fact, if you know the same-sex marriage case that ended with Obergefell, that's exactly what happened. The Massachusetts Supreme SJC decision in Goodrich in 2003 was the first state court, by the way, not to follow an existing U.S. Supreme Court decision which had rejected the right. So in 1972, the U.S. Supreme Court had said no to a constitutional right to same-sex marriage. In 2003, the Massachusetts State Court becomes the first state court to look at its constitution to figure out whether norms have changed and whether there ought to be a constitutional right to same-sex marriage. Lots of states responded in lots of different ways, and roughly a dozen years later, the court announced its Obergefell decision. Whatever one thinks about Obergefell, in my view, no one can deny the propriety of what the court did in terms of looking and waiting to see how the state courts handled this first. At a minimum, that was appropriate. and that's probably, in my view, exactly how it ought to work going forward. Now, the New Hampshire Supreme Court, I should point out, is well ahead of most states when it comes to taking seriously its duty to construe the New Hampshire Constitution independently of the U.S. Supreme Court. The court's recent decision in Cora, a search and seizure case, offers a wonderful example of just what I'm talking about. Now, let me end by mentioning one New Hampshire Supreme Court justice who back in the 1980s was acutely aware of these issues. He spoke for many state court judges, I suspect, when he identified the complicated role of the proper relationship between state and federal court interpretations of identical language. Here is what he said, quote, "If we place too much reliance on federal precedent, we will render the state rules a mere row of shadows. If we place too little, we will render state practice incoherent." The decision was Bradbury, and the justice, of course, was your own Justice Souter. So thank you. What do you think?
I was blindsided. Actually, no, seriously, when you were quoting that, I thought, I don't think I would have said that. I thought, is he going to end up on a funny note? And I said, yeah, I don't think that's my language, but.
I thought it was really good.
Oh yeah, I do too. That was the hard part.
No, it's in the book. It takes a prominent place.
I want to, Judge, I want to congratulate you for two things. First, what you said, which is worth many, many afternoons like this one to listen to and to think about. And the second one is your success in delivering it. Some people here may recall, you I know do, that really the first blast in the trumpet for a kind of revival of state constitutionalism, or at least the first blast that I remember, was from Justice Brennan. And he published an essay advocating such a move in the Harvard Law Review in 1977. But the funny story behind it, for which I'm indebted to Steve Wermeel's biography of Justice Brennan, is that the article basically, I was going to say grew out of, it may have been darn close to verbatim, a speech that Justice Brennan began to deliver to the New Jersey Bar Association in 1976. And he was basically standing where you have been standing this afternoon. And unlike this afternoon's performance, what he witnessed was a dwindling of the audience. And finally, it got to the point where 2/3 of the people there had gotten up and left. And Justice Brennan said, to hell with it, shut his notes and left. And I haven't seen a person go out the back door.
I went to high school in New Jersey. That's a reflection on the difference between the people in New Hampshire and New Jersey.
Well, there may be other reasons too. I think by the way, I should tell you all that Judge Sutton and I have talked about this subject before, so we have not rehearsed anything for this afternoon, but he will not be surprised. I know he's not surprised that I don't have any argument at all to make in principle against the proposal in terms of constitutional government in the United States. What you have heard from the judge is sort of an argument for motherhood, and I would not be so foolish as to oppose him on that ground, and I would not on the merits. I couldn't on the merit on the theory. I couldn't agree more. My only concern about the move toward state constitutionalism is a very practical one. The impetus, by the way, also, I should mention another disclaimer. I have not been doing any state judging since the year 1990. And there's no question that some of what I'm going to say is influenced by what I think I remember from cases in those days. And believe me, I do not warrant that my experiences then would be my experiences now if I got translated to the New Hampshire Supreme Court today. So take it with, as you said, Jeff, with that grain of salt. But the experience, at least, that I think I have had, and which I think is probably a general one, is that the enthusiasm for state constitutionalism tends to come at times when there seems to be, particularly in the field of civil rights and civil liberties, a retreat from sort of generous interpretation on the part of the United States Supreme Court and the federal courts. I mean, that was basically the motivation behind Justice Brennan's proposal. Don't let them take it away from you because your state Supreme Court can give you the same thing. You don't have to lose. And as a consequence of that, there's a kind of Me Too-ism in periods in which, as I said, the warmth toward a renewed state constitutionalism seems to be greatest. And although I do not remember any specific case when I was on the New Hampshire Supreme Court, I do recall having the impression that the tendency on the part of counsel, who basically wanted to protect some level, usually, of civil liberties, was the level of argument tended to be sort of, you can do it too. And it seems to me that, it seemed to me at the time that there tended to be a less developed argumentative grounding for what was sought, and instead a kind of deference to, if they can do it, you can do it. And that's the thing that scares me, because if state constitutionalism is going to go beyond the copycat stage when there seems to be we'll call it a federal retreat on some issue, then in a very literal, crude way, somebody's got to pay the bill. Because as the judge indicated earlier in speaking of the level of generality of many of the provisions that give rise to the sort of most ardent arguments one way or the other, one can't simply read the stuff and know what the answer is. What one can read are a series of guarantees in the form really of value statements. And one has to know what those values are, because the assumptions, e.g. in, for example, the religion clauses, may very well have been different in a given state from the assumptions on the part of the ratifiers following the 1787 draft of the federal Constitution. And secondly, in order to reconcile what are characteristically value competitions or value classes, there has got to be some kind of developed argument. And if the kind of research that is required for the history of the value system, and the kind of research that is required for contemporary digging for the basis of coming to predictions of what will happen one way rather than what will happen another way, somebody's got to do a lot of work. And if that somebody is a private client, there's going to be a big bill. And if that work is not going to be done by the lawyer, if it's going to, in effect, be thrown into the court's lap without much time, there's got to be a lot of judicial time expended. So all of that, to me, boils down to the question, how in the argumentation for revival or vitality of state constitutionalism, how do you deal with the problem that there tends not to be at the state level the degree of scholarly activity and, in effect, ready-made research that there is at the federal activity? Because it's going to cost money.
Yeah, that's, I'm a bit of a dreamer, and I really hate when people force me to ground my dreams in reality. But let me try. This is a very serious problem, and I would say there are a lot of chickens and there's a lot of eggs when it comes to how we got to this particular place. But from the perspective of the lawyers, my first answer is that there are a lot of institutional lawyers in America. There are public defenders' offices, there are state prosecutors, there are interest groups, there are some clients that can pay a fair amount for research. So one point is that you really have to take the long view and decide when a case or a topic is worth looking into. This is mainly a group of lawyers, and I think we would all agree it's kind of nice to have a clean slate. I, for one, always loved it when I had a clean slate, a, quote, issue of first impression. I thought that was where the creativity of the lawyer would come to the fore. The second point I would make is, while I think the history is going to be very important for some of the state constitutional arguments, I think what Justice Souter said at the outset is going to be true more often. It's really just a form of common law reasoning. We should think of state constitutional law a lot like torts, contracts, and property. We have some general guarantees which tell us that we're in the context of a takings claim. We're in the context of free speech. But after that, it's sheer common law reasoning, just what you learned in 1L of law school. Working through a problem, trying to come up with a theory that made some sense and led to outcomes that made some sense, followed by later cases in your state or in other states taking their own looks at it. From the court's perspective, there are many ways in which what I've said is utterly outrageous. State courts handle 95% of the cases in this country, and along comes this federal judge that says, oh, I've got an idea. Here's a second issue you can address in every single case by having state constitutional claims along with the federal claims. So I get it that they're very busy courts. Where are they going to have the time to do this if no one's doing the work for them? So one answer is the state courts are allowed to ask for extra briefing. My court all the time will appoint an amicus if an issue has not been well briefed and we think it's important. Professors are often willing to do that if they think it's an important issue. So that strikes me as another way to think about it. The other thing I would say, which is this is really the Buck versus Bell point that just astonishes me. The problem that I perceive is not a post-Warren Court problem. This problem existed in 1927. In 1927, this country looks at a decision by Oliver Wendell Holmes and says, that's not challengeable under any constitution. That is a feature of American legal culture, which I would call equivalent to Stockholm Syndrome. No, you don't have to do this. Oliver Wendell Holmes, great justice, but a human justice, and no one is immune from mistakes, and everyone should keep that in mind. And so, there's only one state in the country that's better than the New Hampshire Supreme Court, and when I say better, it's by Jeff Sutton's very odd way of measuring better. But the Oregon Supreme Court has an approach that, in my view, solves all of these problems. It says it will never reach a federal constitutional claim until it is determined that all process due the plaintiff has been provided. Part of that process happens to be any guarantees in the state constitution. Now, when Hans Linde started the Oregon Supreme Court down that road, no one was happy. His colleagues weren't happy, the lawyers weren't happy. It took 15 years to make that part of the Oregon culture. Guess what happens in Oregon now when it comes to looking at their decisions? They don't have enough federal con law decisions. All they have are state con law decisions. That's now the most developed part of Oregon, quote, well, American constitutional law in Oregon is on the state side. It took 15 years. It took someone with a lot of guts and leadership, and that's what happened. So lawyers in Oregon don't say, oh shoot, I've got to research 2 claims. They go right to the state claim, and that's usually where it ends. Every now and then the US Constitution goes further, and they have to consult that. But I have to recognize I'm a dreamer, and dreamers usually lose, but they're often happy.
Well, I hope to leave a smile on your face before the afternoon is over, but I guess I gotta say 2 things. I want to address the Oregon point, but one reason that I am not wholly convinced by what on the face of it I think is a very plausible argument or answer to one of my objections is this. My objection was, who's going to do the research, who's going to pay the bill, and so on. And you quite rightly say, well, there are respectable interest groups, and they're going to come in on a case if there's an opportunity to do it. There are scholarly interest groups who are going to come in with scholarly research. I guess the reason I'm not totally convinced that answers the question, the problem, is that it seems unlikely to me that, and at least my experience with amicus briefs on the U.S. Supreme Court leads me to think that it's unrealistic to think that those kinds of virtually national or regional organizations are going to be doing a lot of digging in what is specific to one state. And the argument for constitutional judicial federalism is basically at the political theory level an argument for the legitimacy of individuality in the states. The people of the states get what they in their states want through the legal process. And as a consequence of the fact that I am skeptical of how specific to state constitutions the larger interest group submissions will be, is the notion that what they are more likely to produce is simply an alternative, broadly applicable alternative rationale to whatever has or has had the imprimatur of the Supreme Court. And what you're going to get is not so much judicial federalism as essentially 2 more or less national views on the subject. The views that won in the Supreme Court, and if there is a difference, the views that the large scholastic and interest group council can provide. And believe me, it is a good thing. I will grant you this. It is a good thing to have 2 views with blood circulating in their veins. But I am not sure that it amounts to the kind of federalism that is really the impetus for the argument that Justice Brennan started and that you make. The second thing I just want to make a point on is you mentioned that after Hans Linde in Oregon argued that so long as a state constitutional issue has been raised, you never get to the federal issue until you first have resolved the state issue. And you said that people were unhappy at the beginning, and I want to put myself on record as still being unhappy for this reason. Not in all cases, but consider the situation to which his rule would apply. in which there, and let's again confine ourselves to the personal liberties cases, because those are the ones which are really riding on this concept. Consider the situation in which the Supreme Court of the United States has already recognized the right, the liberty, the immunity, whatever it is, so that so far as existing federal law is concerned, the plaintiff is going to win. And yet, instead of going directly to the law that is there, one starts with state constitutionalism on an issue in which the law has never been decided. I won't say I'm a cynic. I think I'm a realist. The fact is, when you know how it's going to come out anyway, you are not going to really feel the fire in your belly to make the strongest case for what is, as a practical matter, an essentially superfluous decision. And I guess I will stand by that, either realism or cynicism. I think the old common law rule of don't decide anything you don't have to decide, because you are more likely to go astray if you are coming down with pronouncements that don't have to be made. I think that old rule is the answer to the Lindy across the board group. Now, if there is no answer, federal or state, I'm happy to join the crowd with him. But when the feds already have something in place so that the outcome, in fact, can not be other than the existing federal rule, then I think it's perverse.
Well, oh shoot, perverse and cynical. Darn, I got a lot to deal with. I have to say, this is one of the few times in the last couple of years I've thought about leaving the bench. And the reason is I miss arguing cases so much in front of someone like Justice Souter. So I guess I have to move out here to argue in front of the First Circuit. But
don't worry, he's not going to leave.
This is so much fun. Well, first of all, I have to say my view is perverse, and let me explain. And I don't know that it will persuade you, but this is the only way to make state constitutionalism neutral. The critique of it has always been it's a ratchet. Justice Brennan came up with it. It's only to help liberal causes, and therefore, if you're conservative or independent, the last thing you want is a purely one-way ratchet. There's only one way to avoid that problem with state constitutional law cases, and I can illustrate it with the Utah case. So we all know the Fourth Amendment of the U.S. Constitution has an exclusionary rule. It therefore is a purely academic exercise, or was a purely academic exercise for a justice on the Utah Supreme Court to go through the research to figure out whether Utah, under its constitution, had an exclusionary rule, right? Who cares? Because the federal one already has an exclusionary rule. Well, in truth, it mattered in two ways. Remember what I said before. This is good for originalists. It still has an independent value for a state court to tell us what that constitution meant. It's true, it has zero practical consequences, often in the very case before you. But at the end of the day, it ultimately is highly relevant what state courts think for better going up or worse going down when it comes to those guarantees. Once that decision's made, so in Utah, they haven't quite gotten there, but hypothetically, let's say the Utah Supreme Court decides there is no exclusionary rule under our state constitution. The very relevant thing that has happened in Utah when that happens, or if it happened in Oregon, would be you just don't bring a search and seizure claim as a criminal defendant under the state constitution. At that point, all you have is the federal constitution. So it is, Justice Souter is entirely right that there is some advisory opinion work going on. By the way, the state courts are allowed to do advisory opinions. That's for another lecture. But there's no Article 3 prohibition there. It is inefficient, but it does provide relevant data points, And in my view, it's the only way to avoid what has been the key attack on independent state constitutionalism, which is it's a one-way ratchet. And we have to avoid that, or it'll never get anywhere. Justice Souter's first point is completely right, that, well, there is no interest group for federalism. There are only fair-weather federalists in this world. Sometimes you like what the federal government has done, and it turns out in those cases you might be inclined to say they have the power. Other times you don't care for what they're doing, you might be inclined to say they don't have the power. There is no interest group. Since the Federalists and the Anti-Federalists, there just has never been a political party or an interest group that is neutral on that point. They don't have an interest in independent state constitutionalism. I actually think this is one of the big problems. Justice Souter's completely right that all they're going to give you at the state level, the ACLU, the NAACP, the Chamber of Commerce, they're going to give you the junior varsity argument, which is the argument that failed at the U.S. Supreme Court. Because their interest is in nationalizing these issues, and it always will be. But now this gets to the thing that is probably motivating me more than anything else when it comes to state constitutionalism. Winner-take-all fights at the U.S. Supreme Court, this is not going to end well for us. We have two options in this country. Option A is the conservatives and liberals just say, if you can't beat them, join them. You get these rights, we get these rights, and we just keep going up and up and up. Option B is we have a détente, and a détente says that on both sides we're going to do less rights recognition. What is the only politically palatable way in which option B is even remotely realistic? The only way option B, my preferred option, is remotely realistic is if we have vigorous state constitutionalism. Because we Americans like our judicially enforceable rights. That's not going away. And if there'll never be a détente at the U.S. Supreme Court, I think it's probably unrealistic anyway. But it's only realistic if Americans know that in their state Supreme Court justices are going to take seriously these guarantees and construe them independently of the U.S. Supreme Court. So, yeah, I mean, I feel perverse, cynical, and everything else, but I still think it's right. So, what else do you do?
You know, the difference between our exchange today and what the judge very kindly referred to as the days when he was appearing as counsel. In those days, all I had to do was ask the questions. I didn't have to win the argument.
You were always winning the argument.
I kind of like the old forum. But, may I ask you a question?
Oh, yeah.
Do you think, I'll tell you why I get to this, but I'll pose the question first. Do you think that the, let's say, a vigorous kind of two-forum system with vigorous state constitutionalism will in the long run have an effect on sort of on constitutional theory? And the reason I pose the question is this. As you said, and I picked up on it a little while ago, so much of the litigation that really does get the blood flowing is litigation about individual rights. You know, there are structural cases, yes, but they tend not to be the ones that inflame people. Given that fact, those cases turn on what, again, you said, and we all recognize here as terms of very high generality. The freedom of speech, unreasonable search and seizures, and so on. When construing those kinds of provisions, there aren't very many people around today, if any, who take a kind of specific intent originalism and say, you know, only these specific situations in the mind of the drafters, et cetera, and the ratifiers can ever be covered by this general language. Rather, whether one begins from an originalist standpoint or a more pragmatic standpoint or whatnot, what counts in deciding those cases is the reasoning that explains why you go one way rather than another. And if there is a two-tier system, so that on given issues, even at the risk of superfluity in some cases, there are counter analyses from the bench. Is that recognition, or let's say, is people's recognition of the fact that with identical or virtually identical language, different analyses on their face can come to different, presumably legitimate conclusions, arguably legitimate conclusions. Do you think the realization that is the way things are, that you can start with the same language and you can have a reasonable basis for going one way or another, likely to sort of instill in people and in lawyers and in judges a tendency to take the more, what has been called the more American pragmatic view of constitutional interpretation than, say, strict textualism or originalism?
Yeah. So, I think there are certain core American values. You won't be surprised if I now say embedded in the early state constitutions, but we'll ignore that for a second. But there are certain core American values that are core across guarantees. I can't imagine a state saying there's no such thing as a marketplace of ideas when it comes to free speech, or we have to protect the speech we hate. There are some things that are so much a part of what we Americans think. The idea of disagreement is just not there, and it's not going to happen. So that leads to the problem of what about these generalized guarantees as applied to modern debates, arguments we're having, and what's the outcome if we develop an American legal culture where we say, it's pretty reasonable for the U.S. Supreme Court to think this, these 5 states to think this, and these other 10 states to think this. I, for one, would be very happy about it because I think it acknowledges just a fundamental reality of judging that whatever we do is going to be imperfect. And I much prefer, now I'm the realist, the reality of saying that, yeah, the U.S. Supreme Court did its best with this. This is how they looked at it. But I very much like lawyers going to law school and being told not that there's only the tiers of review for equal protection, but there's actually these other 2 models that have been developed. I think that leads to more humility, not less. I think the justice is right. It probably, on balance, is preferred by people with pragmatic tendencies. But those debates are. Everyone's a pragmatist in some way, and everyone's an originalist. Everyone wants to know what it originally meant if you can figure it out. So I don't know that it changes or eliminates those schools of thought. I think what I would like the most about it, however, is judges acknowledging, professors acknowledging, lawyers acknowledging that the phrase due process can have a couple reasonable sets of meanings, and no one should get too sanctimonious about theirs. And let's live and learn from the experience of each one. Obviously, if there are more people doing it, there are more experiences. So I guess I would always like that. That must be the pragmatist in me. But I have thought, though, with vigorous state constitutionalism, will we undermine the credibility, the authority of the U.S. Supreme Court? And I guess I think not. As long as what's being done is reasonable and not being done because someone's just against the majority of the court, but just as taking an honest look at the language and in some cases coming up with a different interpretation. I would not think it was very healthy if what it led to is just a we they, red-blue state courts. That strikes me as the worst of all possibilities. And if that happens, I'll be a very unhappy man. But I hope that's not the real risk here.
Well, I got to tell you, you could win a case in front of me with an argument as good as that answer.
Well, you're so nice to. Thank you for being here. This is so much fun. Can we do this for 2 or 3 more times tonight? Should we take some questions, or are there anyone have any questions, or? Yes.
So I wonder if there may be
Don't bet a lot of money on it.
I wonder if one difference is you talk about the fact that state constitutional development may be tied more to what the individuals in any particular state think. But in this world, there's a different form of money that comes into that equation. If you take the example in Iowa, where the Iowa Supreme Court, I believe it was Iowa that upheld gay marriage, and then enormous sums of money were thrown into the state to attack that decision of the judges who issued it. In the current world, is it really clear that state court decisions, state court constitutional decisions will in fact implement the will of citizens of the state? Now you can say, I suppose, well, they voted those justices out of office, so it was their will. But that dynamic of those kinds of constant changes couldn't be a particularly good thing.
Well, you in New Hampshire, you're very lucky to not have elected judges, so you've spared yourself that problem, and I think it shows in your jurisprudence. So stand by that. You know, I used to be very, very critical of electing judges until I went through the federal confirmation process. It took 2 years. I was confirmed 52 to 41. That's not what they call a big mandate in Washington. And I have to say, I think it's gotten worse. That was 15 years ago. So I think I'm very unhappy with all of our methods of judicial selection, even though I happen to think the federal New Hampshire model is still better. But it's problematic across the board. One downside of electing state court judges is the risk of, the question of whether they're going to have the courage of their convictions, knowing that they've got an election in a year or two. The Iowa case illustrates that point perfectly. And I think it has hurt state constitutionalism, because if I were an elected judge in Ohio, would it not be safer for me to suggest in my opinions that the U.S. Supreme Court made me do it? Because if that's the way the opinion reads, it doesn't look like it was my fault. It looks like it's the U.S. Supreme Court's fault. And I think that is a problem. I mean, that's an unfair accusation to make it to elected state Supreme Court judges, but I just know if I were a state court judge and I was elected, I might think that. What I'd like to see, we have a lot of wonderful people going on the state courts. What you really want in a state court, what you really want in a judge, period, is someone who doesn't need the job. I mean, if you want to change American legal culture, that would be the way to change it. That someone that really believes in it, believes there's such a thing as neutral judging, is going to stand by it, and if it means they're not popular, they're not reelected, so be it, because they didn't go on the court for power, they didn't go on the court to be reelected, God knows they didn't go on the court for pay, so that's what you need, and I can't say we have that right now. But there are a lot of terrific state court judges out there. I mean, the California Supreme Court, I would match with any court in the country right now. If you were to go look at their resumes, you'd go, oh my gosh. I mean, if there's a Democratic president, they'll have 3 people on the short list. I mean, it's not, if top 10, there'll be 3 people from that one court on the short list for a Democratic president. So it's a very, very good court. So I'm hopeful that things are improving, but you're right to worry about it. The Iowa situation is complicated. I know that issue very well, and I believe in sovereignty. The people of Iowa created a system, and they're allowed to do what they did with it. You have to wonder about the lesson it teaches for the next controversial case, and I do worry about that. And I haven't been following the court well enough to know what the aftermath has been. I know there were some justices replaced, of course, but I don't know what their judging looks like. I do know of a case, though, where they're still very attentive to independent state constitutionalism. So they're still doing it since that, particular event.
Sutton, I wonder if you have an opinion about why state courts haven't developed a larger body of law like the Bivens actions. In other words, for money damages for violation of the state constitution, let's say the Fourth Amendment.
I don't know. If you were to read my Bivens decisions, they would suggest a not very kind answer. which is that Bivens didn't make any sense to begin with, and good for the state courts in not following it. I don't know that that was the answer you were looking for. So for the rest of the audience, a Bivens action is an implied action that a federal official or someone can bring against a federal official for violating some constitutional rights, not all. Fourth and Eighth Amendment had been the two. Most claims when you're claiming a constitutional violation are brought under 42 U.S.C. 1983 actions. I haven't done a study of this, so I really should just plead ignorance, but my suspicion, I do know Ohio, my suspicion is you just don't need Bivens actions, that the state legislation already provides a waiver of sovereign immunity, a court of claims to go to for bringing those particular claims. So, Bivens is a necessity decision. They did this in 1972 or whatever, because it seems so strange that people, victims of a federal constitutional violation, had no recourse. I suspect most states there is a recourse, but I must acknowledge I don't know. Yeah.
I'm very sympathetic to Justice Souter's critique of your argument, in particular that if a state court has an issue that could be decided either with federal or state constitutional law, why bother with the state analysis if the answer is already provided by the federal analysis? In fact, perhaps even go stronger, that it's illegitimate for them even to be talking, and not just because states can provide advisory opinions, they shouldn't be providing advisory opinions, even if they're allowed to. It's not in keeping with our Anglo-American tradition of common law judging. But let me suggest that maybe the possibility for solving the problem is somewhere else, and that is that it's rests ultimately with the Supreme Court for its overreaching its boundaries. That is, work which took place a long time ago. The First Amendment says Congress shall make no law. Well, this is Congress, this is the interpretation of an amendment to the federal Constitution. One can say, I hope one can still argue, that really has nothing to do with what happens with state governments and what it does. It seems to me that the best way of what you want to see happening is for the Supreme Court to adopt some humility and say, we're only going to interpret the federal Constitution as it applies to the federal government. States, they can keep on doing it. No more incorporating 14th Amendment and all the other First Amendment rights and applying it to the states.
Well, you're certainly right as a practical matter that the more the U.S. Supreme Court does, the less any state court needs to do anything, and the less plaintiffs will come to state court seeking relief. Why would you do that in the middle of the Warren Court era if you're, say, representing a criminal defendant, when the odds were so good that you'd get a good audience, and indeed, if you won, you'd nationalize the right? And I'm afraid the opposite's true. The less the U.S. Supreme Court does in rights innovation, the more room there is for going to the states. So I do think those two things are true. I'm willing to confess error on your first point and Justice Souter's good point, as long as these are the terms of my error. The reason a lot of people find it funny that you would have to decide the state law issue when you have existing federal constitutional law precedent is because there is so much federal constitutional law precedent and so little state constitutional law precedent. So the terms of my confession of error are that we go to a world where there is plenty of constitutional law, we'll call it American constitutional law, on the state and federal side, and then in any case in which the state's a clear winner, don't go to the federal. If the Fed's a clear winner, don't go to the state. Then I think I'd be happy, and I agree, it'd be way more efficient. I don't know that the court is going to undo incorporation. I mean, that strikes me as a hard sell. But and for me to be saying that, you really have to listen, because I try everything on this federalism stuff. So if I'm not willing to push that, I'd be very nervous. Other question? One more question. Time for one more question. All right, great, thanks.
So was there a heyday of state court or state constitutional interpretation sometime, I guess, after 1787? Was there a time when it was the state Supreme Courts were very active in interpreting the state constitutions, very much so in the way that you suggest? And if so, what happened to
Oh, such a great question. So, and it's so sad that I partly know the answer, so I don't get invited to cocktail parties. So if you were to do something I've done, again, you won't be invited out again, and start looking at treatises in the mid-1800s, 19th century, and you looked, first of all, the treatises would all be called American constitutional law. 4/5 so it's federal and state. No one has that anymore. The treatises are now all federal. And so it would be federal and state in the same treatise, and 4/5 of it would be on state constitutional law. So clearly, I'm living at the wrong time, all right? That was clearly... But I'll tell you the other thing that is another way of answering your point about the golden age. You have to remember that this is just an American history point, that most of the constitutional litigation for the first 150 years is primarily structural. That's really what's going on, whether at the state or federal level. It's really, you really have to say it's Jim Crow that leads us as a people to take much more seriously all these individual rights protections. And so that's a change that was happening at the same time. And so I was very surprised. I would have thought the golden era of state individual rights protections would have been the early 1900s. And as my story showed, there were some good decisions. But Buck v. Bell comes out and they say enough is enough. We're not going to contradict them. So you got to give the U.S. Supreme Court credit. That's credibility. That's their credibility, and I'm glad for it. But, maybe just not quite that much would be great. Well, thank you to Justice Souter for being with us. This is so much fun for me and obviously for you. So thank you.